On this particular morning, during a high-stakes hearing on voting rights, precisely such a moment occurred. A freshman congresswoman, arguing her first case before the court, delivered a presentation so clear, so constitutionally grounded, and so deeply connected to the human impact of the law, that it elicited an unprecedented public compliment from the normally stoic Chief Justice himself. This is the story of that remarkable exchange, a testament to meticulous preparation, profound legal understanding, and the enduring power of principled advocacy in America's highest court. The Supreme Court chamber fell completely silent, a hush descending over the packed gallery. Chief Justice John Roberts, known for his stoic demeanor and his precise control over the courtroom proceedings, suddenly removed his reading glasses. He leaned forward in his high-backed chair, his eyes fixed intently on Congresswoman Jasmine Crockett, who stood calmly at the advocate's podium. What had begun as a technically complex, though constitutionally significant, hearing on voting rights legislation was about to pivot into a moment that legal scholars and court observers would discuss for decades. Congresswoman Crockett, the Chief Justice said, his voice carrying clearly through the hushed, almost reverent, atmosphere of the courtroom, "I must say, I have rarely encountered such clarity of thought under such intense questioning from counsel." A quiet ripple of surprise went through the gallery. Journalists exchanged astonished glances. Supreme Court justices, and especially the Chief Justice, simply did not offer direct compliments during oral arguments. Their questions were probes, their statements challenges, their demeanor designed to maintain an austere impartiality. But the Chief Justice was not finished. He offered Crockett a distinct, deliberate nod, a gesture of unmistakable respect that spoke volumes within the intensely formal setting of America's highest court. In that single, unscripted moment, a first-term congresswoman from Texas, a former public defender arguing her first case before this august body, had earned something vanishingly few advocates ever receive: the clear, public, and personal respect of the nation's top jurist. To fully appreciate the extraordinary nature of this exchange, it is essential to understand the two remarkable individuals at its center and the high-stakes case that brought them face to face. Chief Justice John G. Roberts, Jr. had presided over the Supreme Court since 2005. A graduate of Harvard Law School, he had built an impeccable legal reputation long before his appointment. He clerked for then Associate Justice William Rehnquist, served in high-level positions in the Reagan administration's Justice Department, and established himself as one of the nation's preeminent appellate attorneys, arguing an impressive 39 cases before the very court he would eventually lead. As Chief Justice, Roberts had become known for his careful, methodical, and often minimalist approach to constitutional questions. His primary concern, as noted by countless court observers, was the institutional legitimacy and reputation of the court itself. He abhorred heated rhetoric and preferred narrow, technically precise legal reasoning, often seeking incremental shifts rather than broad, sweeping pronouncements. Appointed by President George W. Bush, he was a conservative jurist, yet he had occasionally broken ranks, most notably in upholding the Affordable Care Act, demonstrating a complex judicial philosophy guided as much by institutional concerns as by ideology. Roberts sees himself as the guardian of the court's legitimacy. Noted one constitutional scholar, he is extraordinarily careful about maintaining the dignity of the proceedings and almost never displays strong emotion or personal opinion from the bench. Across the courtroom stood Congresswoman Jasmine Crockett, representing Texas's 30th congressional district since 2023. Her path to this moment had been markedly different. Before entering politics, she had forged a formidable reputation not in corporate law or appellate advocacy, but as a civil rights attorney and public defender in the trenches of the Texas justice system. Born to working-class parents, she had witnessed firsthand the ways in which seemingly neutral laws could disproportionately affect marginalized communities. After earning scholarships to Rhodes College and the University of Houston Law Center, she dedicated her legal career to voting rights litigation, often representing clients in communities with long, painful histories of disenfranchisement. What makes Crockett uniquely effective, noted a voting rights expert, is her seamless combination of deep constitutional knowledge and a profound, personal understanding of how these laws impact real people on the ground. She doesn't just cite the case law, she knows the human cost. The case before the court, Henderson County Election Commission versus United States, was a potential landmark. It challenged a recently enacted state law that had closed over 200 polling locations, predominantly in minority neighborhoods, under the guise of optimizing electoral efficiency. While the law contained no explicit racial language, its practical impact was stark. Minority voters now had to travel, on average, 5 times farther than white voters to cast their ballots. Lower courts had split on whether this disparate impact violated Section 2 of the Voting Rights Act, which prohibits voting practices that result in discrimination. Even without proof of explicitly discriminatory intent, the Supreme Court had agreed to hear the case, recognizing its potential to significantly reshape voting rights jurisprudence nationwide. The morning of oral arguments arrived, and the tension within the Supreme Court chamber was palpable. The gallery was packed shoulder to shoulder. Crockett entered, wearing a simple navy suit, carrying only a slim binder. Her preparation was evident not in stacks of reference materials, but in her focused presence, her calm demeanor. Chief Justice Roberts opened the questioning, his tone neutral and academic. Congresswoman Crockett, your brief argues that this polling place allocation formula violates Section 2 of the Voting Rights Act. Despite containing no explicit racial classifications, how do you establish discriminatory result, or potentially discriminatory intent, when the text of the law appears facially neutral? Crockett approached the podium, her composure absolute. Mr. Chief Justice, and may it please the court, she began, her voice clear and respectful. The court's decision in Village of Arlington Heights versus Metropolitan Housing Development Corp. Provides the established framework. We must examine the totality of the circumstances, including the historical background of the decision, the specific sequence of events leading up to the challenged decision, any departures from normal procedural sequences, and, critically, the law's practical impact. She continued without consulting her notes, demonstrating a mastery of the complex legal standard. In this case, Mr. Chief Justice, all relevant factors point decisively toward a discriminatory result prohibited by Section 2, and strongly suggest discriminatory intent as well. The state's own pre-implementation analysis predicted these closures would burden minority voters at 3 times the rate of non-minority voters. Furthermore, alternative, less discriminatory plans that would have achieved the same stated efficiency goals were presented to the state legislature and were rejected without substantive explanation. The foundation of her argument was laid. This was not mere coincidence, it was a foreseeable and avoidable discriminatory outcome. Chief Justice Roberts nodded slightly, absorbing her answer, his expression remaining neutral. The questioning then moved down the bench, a gauntlet of probing inquiries from the associate justices, each with their own distinct judicial philosophy and line of attack. Justice Samuel Alito, known for his skepticism towards disparate impact claims, leaned forward, his tone sharp. Congresswoman, correlation is not causation. Couldn't these disparities simply be the result of neutral factors like population density shifts or pre-existing geographic clustering unrelated to race? Justice Alito, I agree wholeheartedly that correlation alone is insufficient, Crockett replied, surprising him with her immediate concurrence before pivoting. That is why our case does not rest solely on statistical disparity. We have presented specific evidence demonstrating how the state arrived at this formula. She carefully removed a single document from her slim binder. This internal memorandum from the Secretary of State's office, obtained during discovery, explicitly acknowledges that the proposed formula would, and I quote, significantly reduce turnout in District 7 and District 12, areas which, the memo notes, historically vote heavily Democratic. Given the well-established correlation between race and partisan preference in this state, a correlation documented in multiple federal court decisions, this statement provides compelling circumstantial evidence that the disparate racial impact was not merely foreseen, but was understood in partisan, and therefore implicitly racial, terms. Justice Elena Kagan jumped in, focusing on the state's justification. Counsel for the state argues that severe budget constraints necessitated these closures. How do you respond to the efficiency argument? Crockett's response was measured but forceful. Justice Kagan, the record directly contradicts that justification. While the state was implementing these closures in predominantly minority urban areas, Citing budget constraints, they simultaneously allocated $4.2 million in new funding for the construction of additional polling locations in predominantly white, affluent rural areas where no access issues had been identified. This selective application of fiscal concern further supports an inference of discriminatory intent, or at the very least, demonstrates that the disparate impact was not an unavoidable consequence of a neutral, budget-driven policy. Justice Neil Gorsuch, a staunch textualist, pressed her on the language of the law itself. Congresswoman, the text of the statute allocating polling places contains no mention of race whatsoever. Are you asking this court to look beyond the plain language of the statute to infer a discriminatory purpose based on extrinsic evidence? Doesn't that conflict with our established principles of textualism? Crockett met his gaze directly, her response demonstrating a sophisticated understanding of his own judicial philosophy. Justice Gorsuch, textualism does not require willful blindness to context or consequence. Indeed, in Village of Arlington Heights, this court explicitly recognized that even facially neutral laws may serve as an obvious pretext for racial discrimination. The text of the law matters immensely, but this court has consistently recognized, as far back as Yick Wo v. Hopkins, that the Constitution prohibits sophisticated as well as simple-minded modes of discrimination. A law need not contain explicit racial language to violate the Equal Protection Clause or the Voting Rights Act if the evidence clearly demonstrates it was enacted with discriminatory purpose or produces a discriminatory result. Gorsuch followed up, his questioning becoming more intense. But where does this court draw the line? If we allow challenges based on disparate impact alone, won't virtually any election administration decision, from voter ID laws to precinct boundaries, be subject to endless litigation? How do we determine when a disparate impact crosses the threshold into discriminatory intent without simply substituting our own policy preferences for those of the elected legislature? Crockett didn't flinch. The line is drawn precisely where this court has always drawn it. Justice Gorsuch, by the weight of the evidence, evaluated under the established Arlington Heights factors. She began ticking them off on her fingers. Here, we have contemporaneous statements from officials acknowledging the likely disparate impact. We have procedural irregularities in the law's adoption, including the unexplained rejection of less discriminatory alternatives. We have a clear historical background of voting discrimination in this state. And we have the stark statistical evidence of the law's practical effect. She paused. These are not subjective judicial preferences, Justice. They are the objective, evidentiary indicators this court has long recognized as probative of discriminatory intent. The Constitution requires us to look at the totality of the circumstances, not just the text in isolation. The hearing room remained remarkably still. This was not the typical back and forth of a Supreme Court argument. It was a focused, almost academic, dissection of constitutional law, delivered with a clarity and confidence that held the justices' attention. Justice Brett Kavanaugh shifted the focus from constitutional theory to practical application. Let's talk remedies, Congresswoman. Assuming, arguenda, that the court were to find a Section 2 violation here, what would be the appropriate remedy? Wouldn't ordering the state to redraw its polling place map constitute judicial policymaking? Intruding upon the legislature's authority? Not at all, Justice Kavanaugh. Crockett countered smoothly, demonstrating her command of remedial principles. The appropriate remedy would simply be an injunction requiring the state to develop and implement a new polling place allocation formula that does not impose these disproportionate burdens on minority voters. The state would retain full discretion in how it achieves that constitutional requirement. Federal courts have successfully managed similar remedies in voting rights cases for decades. From Reynolds v. Sims onward. Without engaging in legislative policymaking, the court sets the constitutional floor. The state decides how to meet it. For over 40 minutes, the intense questioning continued. Each justice probed Crockett's arguments from different angles, testing the foundations of her case. Justice Amy Coney Barrett, focusing on historical context, asked, Congresswoman, how much weight should this court give to historical discrimination within a state when evaluating a modern, facially neutral law like this one? At what point does that history become too attenuated to be relevant to current intent or effect? Crockett's answer was both legally precise and historically grounded. Justice Barrett, History matters most profoundly when its effects are still demonstrably present and actively shaping current conditions. In this specific case, we have presented extensive evidence documenting how historical housing segregation policies in this state directly correlate with current residential patterns. Those patterns, in turn, directly determine which communities bear the disproportionate burden of these specific polling place closures. She leaned forward slightly. This isn't distant history, Justice. It is ongoing causation. The state, aware of these historical patterns and their contemporary effects, chose a formula that predictably leveraged those patterns to produce a discriminatory outcome. Then came the exchange that would make legal history. Chief Justice Roberts, who had been unusually quiet but visibly engaged since his opening question, leaned forward again. He posed a complex hypothetical, the kind designed by appellate judges to test the outer limits of an advocate's legal theory. Congresswoman Crockett, he began, his tone purely academic. Let's consider a hypothetical jurisdiction. Suppose it adopts a perfectly race-neutral criterion for polling place allocation, say, 1 polling place for every 5,000 registered voters. Now, if this neutral formula results in fewer polling places in minority neighborhoods solely because those neighborhoods have lower voter registration rates, and those lower rates themselves stem from the lingering effects of historical discrimination, would that scenario trigger strict scrutiny under your Section 2 theory? The courtroom tensed. It was a brilliant question, requiring Crockett to navigate the treacherous intersection of historical discrimination, neutral policies, disparate impact, and the stringent requirements for proving discriminatory intent. A misstep here could unravel her entire case. Crockett paused, considering the question carefully. Her response was a model of legal reasoning, balancing principle with pragmatism. Mr. Chief Justice, she began, your hypothetical highlights what legal scholars often refer to as second-generation voting discrimination, policies that are facially neutral but operate to disadvantage minority voters by leveraging known social or historical patterns. She continued with remarkable precision. Under the Arlington Heights framework and this court's subsequent Section 2 jurisprudence, including Brnovich, the key inquiry would be foreseeability and the availability of alternatives. I would examine whether the jurisdiction knew, or reasonably should have known, based on available data, that their chosen, neutral, formula would produce such severe racial disparities before they implemented it. Roberts pressed further, but where do we draw the line? Congresswoman, couldn't virtually any election administration decision, allocating voting machines, setting precinct hours, be challenged if it produces any statistical disparity, however small? It was this moment that showcased Crockett's exceptional ability to synthesize complex legal doctrine with practical wisdom. The line, Mr. Chief Justice, lies in the rigorous application of the Arlington Heights factors. She responded firmly, not every disparate impact reflects discriminatory intent or result. Some disparities truly are unforeseeable, or unavoidable consequences of pursuing legitimate, non-discriminatory policy goals. The Constitution does not guarantee perfectly equal outcomes in every instance. She paused briefly, then continued with growing conviction. But, Mr. Chief Justice, when a state is specifically informed, through its own data or through credible external analysis, that its chosen method will severely burden the fundamental right to vote for minority citizens, when less discriminatory alternatives exist that could achieve the state's legitimate administrative goals, and when the state rejects those less discriminatory alternatives without meaningful justification, particularly against a backdrop of historical discrimination in voting, then, sir, the Constitution cannot remain silent. As Jasmine Crockett finished her answer, the courtroom remained completely still. Even the justices who clearly disagreed with her underlying legal position appeared engaged, leaning forward, their expressions thoughtful rather than combative. She had not just answered the Chief Justice's difficult hypothetical, she had articulated a clear, evidence-based standard for distinguishing between permissible disparate impacts and unconstitutional discrimination. The 15th Amendment's prohibition on denying or abridging the right to vote, on account of race, wasn't limited solely to explicit racial classifications. She continued, pressing her advantage while the court was clearly focused. The framers of that amendment understood, as this court has repeatedly affirmed, that voting rights could be undermined through indirect, Facially neutral means just as effectively as through direct, overt prohibitions. That is why they chose the broad, encompassing language of denied or abridged, rather than narrower terms. She concluded with quiet force. When sophisticated administrative methods achieve the same discriminatory results as the poll taxes and literacy tests of our past, they must meet the same constitutional fate. Otherwise, we risk reducing the 15th Amendment to a mere formalism, a prohibition only against the most obvious and simple-minded forms of discrimination, while permitting their functional equivalents to flourish under the guise of neutral administration. Justice Clarence Thomas, who rarely speaks during oral arguments, surprised everyone by leaning into his microphone. "Congresswoman Crockett," he began, his deep voice commanding immediate attention. "Many of these communities you speak of had functioning polling places for decades prior to this law. What specific evidence suggests that their closure now, as part of a statewide efficiency plan, represents intentional discrimination, rather than simply neutral, albeit perhaps burdensome, administration?" Crockett turned to address Justice Thomas directly, showing no surprise at his unexpected question. "Justice Thomas, 3 specific pieces of evidence in the record are particularly compelling on the question of intent. First, the state's own internal simulation data, conducted before the law was passed, showed that these specific closures would affect minority voters at dramatically higher rates than white voters. They knew the impact in advance. Second," she continued, "the minutes from the State Election Planning Commission reveal that when this disparate impact was pointed out during deliberations, the chairman responded, and this is a direct quote from the minutes, 'We can't be responsible for who chooses to register or turn out to vote.' This suggests a deliberate indifference to the known racial impact." And third, she added, "alternative plans, such as the one designated Alternative Plan C in the record, were presented to the legislature. These alternatives would have achieved nearly identical cost savings and efficiency goals, but with significantly less disparate racial impact. Those less discriminatory alternatives were rejected without any substantive explanation or justification." She paused, allowing the weight of the evidence to settle. Perhaps most tellingly, "Justice Thomas, the communities most heavily impacted by these specific closures were precisely the communities that had seen record-high minority voter turnout in the previous 2 election cycles. The timing of these closures, immediately following historic levels of minority participation, provides strong circumstantial evidence of discriminatory intent under this court's established precedents." Justice Thomas nodded slightly, his expression inscrutable but clearly attentive. He asked no further questions. As Crockett returned to her seat, having used almost precisely her allotted time, Chief Justice Roberts removed his glasses and set them down deliberately on the bench before him. He looked directly at Crockett. It was then that he spoke the words that would echo through the legal world for years to come. "Congresswoman Crockett," he said, his voice carrying clearly through the hushed courtroom, "I must say, I have rarely encountered such clarity of thought under such intense questioning. While the court will, of course, reserve judgment until our opinion is issued, your presentation today has been a model of constitutional advocacy." The statement hung in the air like a thunderclap. It was an extraordinary breach of judicial protocol, a direct, personal acknowledgement of an advocate's skill offered from the bench by the Chief Justice himself. In the gallery, seasoned court reporters exchanged astonished glances. Civil rights veterans blinked back tears. Crockett, momentarily taken aback by this unprecedented gesture, quickly composed herself. She stood again briefly. "Thank you, Mr. Chief Justice," she replied, her voice filled with characteristic dignity. "While I deeply appreciate your words, what truly matters isn't my presentation, but whether this court will uphold the fundamental right of every American citizen to cast a meaningful ballot, free from discriminatory barriers." It was this response, immediately redirecting the focus from personal praise back to the constitutional principles at stake, that seemed to impress the Chief Justice even further. He offered her another deliberate, respectful nod, a small but profound gesture that sealed the extraordinary nature of the moment. The argument was over, but the impact was just beginning. The weight of the Chief Justice's extraordinary acknowledgement hung heavy in the air as the state's Solicitor General approached the podium for his rebuttal argument. The lawyer, a seasoned appellate advocate who had entered the courtroom that morning with an air of confident assurance, now seemed diminished, facing the unenviable task of trying to reclaim ground that had been decisively lost. It was immediately clear that the momentum of the argument had shifted. The justices, who had earlier pressed Crockett with challenging hypotheticals, now turned their sharpest questions on the state's lawyer, focusing almost exclusively on the points Crockett had so effectively raised. Counsel, Justice Kagan began, picking up immediately where Crockett had left off. Congresswoman Crockett presented evidence, including internal state documents, suggesting that the state was explicitly warned about the disparate racial impact of its chosen formula before implementation. How do you reconcile that evidence with your argument that any disparate impact was merely an unintentional byproduct of a neutral efficiency plan? The Solicitor General struggled to provide a compelling answer, repeatedly falling back on the law's facial neutrality. Your Honor, the statute itself contains no racial classifications. This court should be extremely cautious about inferring discriminatory intent based solely on disparate impact statistics. But we are not talking about disparate impact alone, are we? Justice Sotomayor interjected, her tone sharp. Congresswoman Crockett presented specific evidence, internal memos acknowledging the racial impact, testimony regarding the unexplained rejection of less discriminatory alternatives, and procedural irregularities in the law's adoption. How do you respond to that specific, cumulative evidence of intent? Those internal communications were preliminary drafts. Your Honor, the Solicitor General replied, his voice less confident than before. They do not represent the legislature's final thinking or ultimate motivation. But they do demonstrate awareness of the likely impact. Do they not? Justice Barrett noted, picking up the thread. Doesn't that awareness become legally significant under the Arlington Heights framework, particularly when coupled with the rejection of viable, less discriminatory alternatives? The Solicitor General shifted his approach, attempting to argue for a limited remedy. Your Honors, even if the court were to find a Section 2 violation here, the proper remedy would be narrowly tailored to the specific communities where a disparate impact has been definitively demonstrated, not a wholesale invalidation of the state's entire formula. It was then that Chief Justice Roberts intervened again, his questioning now unexpectedly direct and pointed. Counsel, you still haven't adequately addressed Congresswoman Crockett's central point regarding the rejected alternatives. She presented evidence suggesting that Alternative Plan C would have achieved nearly identical efficiency goals with significantly less disparate impact. If the state's goal was truly administrative efficiency, and not, as she suggests, the reduction of turnout in certain communities, why was that less discriminatory plan rejected without explanation? The Solicitor General, visibly flustered, fumbled through his binder. Mr. Chief Justice, election administration involves complex trade-offs. The legislature weighed many factors. I don't have the specific committee records regarding the rejection of Alternative Plan C before me at this moment. Justice Kavanaugh asked pointedly, Counsel, did the state conduct any analysis of whether the chosen formula would make it significantly more difficult for minority citizens, specifically, to cast their ballots? No, Your Honor, of course not. The Solicitor General insisted. The formula was based purely on neutral administrative criteria. Yet, Justice Gorsuch noted dryly, the state's own simulations, presented by Congresswoman Crockett, predicted exactly that outcome. How do you square that circle? The rebuttal was faltering badly. Even the justices expected to be most sympathetic to the state's arguments were pressing hard on the inconsistencies and evidentiary gaps that Crockett had exposed. The Solicitor General, trapped between the law's neutral language and the stark evidence of its discriminatory effect and potential intent, had no effective response. The final, defining question of the rebuttal came, once again, from Justice Thomas. Counsel, he asked, his voice a low rumble. If we accept your argument that only laws containing explicit racial classifications trigger heightened constitutional scrutiny under the 15th Amendment, aren't we essentially providing states with a roadmap for circumventing that amendment's protections through the use of facially neutral laws that have known and predictable discriminatory effects? The courtroom fell silent, coming from the court's most steadfast originalist and conservative member. The question signaled a profound potential shift in the argument's center of gravity. Justice Thomas, the Solicitor General began cautiously, This court has always required compelling evidence of discriminatory intent, not merely disparate impact. And isn't compelling evidence precisely what Congresswoman Crockett presented today? Thomas replied, his voice even. Internal communications acknowledging the racial impact, unexplained rejection of less discriminatory alternatives, and a historical context suggesting a pattern of behavior. How is that not evidence of intent? The Solicitor General had no answer. His time expired. He gathered his papers, his face grim. The momentum had not just shifted, it had been entirely captured. Jasmine Crockett had not only presented a masterful case, she had effectively armed the justices with the very questions they needed to dismantle the state's defense. As the state's Solicitor General returned to his seat, a palpable sense of finality settled over the courtroom. The arguments had been made, the evidence presented, the weaknesses exposed. All that remained was for Jasmine Crockett to deliver her brief final response. Her last opportunity to frame the case for the 9 justices who held its fate in their hands. She rose and approached the podium one last time. The chamber was completely silent. Every eye was upon her. Mr. Chief Justice, and may it please the court, she began, her voice quiet but resonant. The question before this court today is deceptively simple. Does our Constitution permit states to achieve indirectly, through facially neutral means, what the 15th Amendment explicitly forbids them from doing directly? She paused, allowing the weight of the question to settle. The evidence presented in this record demonstrates, conclusively, that the state knew its chosen polling place formula would severely burden minority voters. It demonstrates that less discriminatory alternatives were available and presented. And it demonstrates that the state rejected those alternatives without substantive justification, proceeding with a plan whose discriminatory effects were not just foreseeable, but foreseen. Her voice gained strength, imbued with a quiet conviction. Throughout our nation's history, the fundamental right to vote has faced repeated and insidious challenges, from property requirements and poll taxes, to literacy tests and grandfather clauses, and now, to sophisticated administrative barriers disguised as neutral efficiency measures. What changes is not the ultimate effect, the denial or abridgment of the right to vote for minority citizens, but only the method. She looked along the bench, meeting the eyes of each justice in turn. This case is not about whether states have a legitimate interest in pursuing efficiency in election administration. Of course, they do. The question is whether they must pursue that legitimate interest in ways that do not predictably and disproportionately burden the fundamental constitutional rights of their minority citizens, especially when less discriminatory means are readily available. She closed her binder with a soft, final click. The 15th Amendment's promise was not merely a negative prohibition on explicit racial classifications in voting. It was, and is, a positive guarantee that the right to vote would be equally available to all Americans. In practice, not just in theory, the voters in Henderson County, the voters in my district, and indeed, voters across this nation who face similar barriers, are simply asking this court today to give full and meaningful effect to that constitutional promise. She bowed her head slightly. Thank you. As she returned to her seat, Chief Justice Roberts removed his glasses and set them down deliberately on the bench. He looked directly at Crockett. It was then that he spoke the words that would stun the courtroom and reverberate through the legal world for years to come. Congresswoman Crockett, he said, his voice carrying clearly through the hushed chamber. I must say, I have rarely encountered such clarity of thought under such intense questioning. While the court will, of course, reserve judgment until our opinion is issued, your presentation today has been a model of constitutional advocacy. The statement hung in the air like a thunderclap. Supreme Court justices simply did not offer such direct, personal praise during oral arguments. Crockett, momentarily surprised, quickly composed herself. Thank you, Mr. Chief Justice, she replied with characteristic dignity. While I deeply appreciate your words, what truly matters isn't my presentation, but whether this court will protect the fundamental right of every citizen to cast a meaningful ballot without discriminatory barriers. It was this response, immediately redirecting attention from personal praise back to the constitutional principles at stake, that triggered Roberts' remarkable final gesture. He offered Crockett another deliberate, respectful nod, a small but profound acknowledgement that sealed the extraordinary nature of the moment. The argument was over. The Chief Justice's unprecedented acknowledgement hung in the air as the courtroom slowly began to empty. Reporters rushed out to file their stories. Legal observers huddled in intense discussions. And the state's legal team departed with grim, downcast expressions. Jasmine Crockett remained at the counsel table for a long moment, quietly gathering her papers, the adrenaline of the argument slowly giving way to a profound sense of exhaustion, mixed with a cautious, fragile hope. As she descended the grand marble steps of the Supreme Court building, she was met by a swarm of reporters, microphones thrust toward her face, questions shouted from all directions. "Congresswoman, what does it mean to receive such a direct compliment from the Chief Justice? Did Justice Thomas's questions surprise you? Do you believe you've won the case?" Crockett paused on the steps, facing the cameras. Today wasn't about any individual lawyer or any single justice, she said, her voice steady, refusing to be drawn into speculation about the outcome or the personalities involved. It was about whether our Constitution's promises of equal protection and the right to vote extend to every American citizen, regardless of their race or where they live. The arguments were presented. The evidence is in the record. The true victory will come only if this case helps secure equal voting rights for all Americans. And we now place our trust in the court to uphold those fundamental principles. With that, she declined further questions and made her way through the throng, leaving the reporters to dissect the nuances of the Chief Justice's remarks and the potential implications for the court's eventual ruling. Inside the court building, the conversation was likely just as intense, though far more private, according to a clerk who later shared details anonymously for a historical account. Chief Justice Roberts returned to his chambers visibly moved by the morning's argument. He reportedly sat at his desk in silent reflection for several minutes before turning to his clerks. "In all my years on the bench," he is said to have remarked, "I have rarely heard the human consequence of constitutional doctrine articulated so perfectly. Sometimes it takes a fresh voice, grounded in real experience, to remind us of our deepest commitments." The weeks that followed the oral argument were filled with intense speculation. Legal news outlets published detailed analyses, parsing every question asked by the justices, attempting to predict the final vote count. Constitutional scholars debated the significance of Roberts's unusual praise and Thomas's pointed questioning of the state's lawyer. Had Crockett's argument truly shifted the court's center of gravity on voting rights? 8 weeks later, the wait was over. The Supreme Court issued its decision in Henderson County Election Commission versus United States. In a surprising 6-3 ruling, with Chief Justice Roberts writing for the majority, the court struck down the state's polling place allocation formula as a violation of Section 2 of the Voting Rights Act. The opinion was a landmark, carefully navigating the complex terrain between disparate impact and discriminatory intent. When facially neutral voting regulations produce severe, statistically significant disparate impacts along racial lines, Roberts wrote, and the record demonstrates that state officials were aware of this potential impact and rejected less discriminatory alternatives without sufficient justification. Courts must conduct a searching review of the totality of the circumstances to determine if the regulation results in an unlawful abridgment of the right to vote. In a direct echo of the oral argument, the opinion explicitly quoted Crockett's own words, as counsel for the respondents aptly observed during oral argument. When sophisticated methods achieve the same discriminatory results as the poll taxes and literacy tests of the past, they must meet the same constitutional fate. This core principle guides our analysis today. The ruling was a stunning victory for voting rights advocates and a personal vindication for Jasmine Crockett. The court had not only sided with her on the outcome but had explicitly adopted her legal reasoning and language. The impact was immediate and profound. The court ordered the state to immediately restore polling places in the affected communities and to develop, under federal court supervision, a new allocation system that ensured equal access for all citizens. The decision became a new touchstone in voting rights jurisprudence, cited by courts across the country. More importantly, it sent a clear signal to state legislatures nationwide that facially neutral laws with predictable, severe, and avoidable discriminatory impacts would face rigorous constitutional scrutiny. The promises of the 15th Amendment, Crockett had argued, must apply in practice, not just in theory, and the Supreme Court, led by its Chief Justice, had agreed. The Henderson County decision resonated far beyond the specific communities whose polling places were restored. It marked a subtle but significant recalibration in voting rights law, emphasizing the court's willingness to look beyond the text of a law to its practical, real-world effects, especially when evidence suggested lawmakers were aware of potential discriminatory impacts. State legislatures across the country began to incorporate disparate impact analyses more routinely into their election administration planning, often proactively consulting with civil rights experts before implementing major changes. For Jasmine Crockett, the Supreme Court victory affirmed her unique approach to constitutional advocacy, one that seamlessly blended rigorous legal analysis with a deep, empathetic understanding of how laws affect real communities. She continued her work in Congress with renewed purpose, becoming a leading voice not just on voting rights, but on a range of issues where constitutional principles intersected with social justice. She focused on legislation aimed at codifying and strengthening the principles articulated in the Henderson County case, ensuring that its protections would endure. Perhaps the most unexpected and enduring outcome was the quiet, respectful professional relationship that developed between Chief Justice Roberts and Congresswoman Crockett. Despite their differing judicial philosophies and political affiliations, they found common ground in their shared commitment to constitutional principles and the integrity of legal institutions. They appeared together the following year at Georgetown Law's annual Constitutional Law Symposium. Participating in a rare joint interview, "What struck me most about Congresswoman Crockett's argument," Roberts explained to the packed auditorium, "was not just its legal precision, but its profound fidelity to the Constitution's deepest purpose, ensuring that our fundamental rights are protected in practice. Not just in theory, good advocacy illuminates the path to justice." Crockett, in turn, acknowledged the Chief Justice's role. "What I appreciated," she responded, "was the court's, and particularly the Chief Justice's, willingness to engage seriously with the evidence, even when it challenged established assumptions. That intellectual honesty is essential if constitutional interpretation is to truly serve the American people." The Henderson County case did not resolve all the complex challenges facing American democracy, but it served as a powerful reminder that progress remains possible. It demonstrated that principled advocates, armed with compelling evidence, can still persuade even the highest court, and that thoughtful jurists can still engage with those arguments in good faith. In a nation often fractured by partisan rancor, the Roberts-Crockett exchange offered a hopeful glimpse of a different path, one where mutual respect and a shared commitment to constitutional values could, even if only for a moment, transcend the political divide. The narrative of Representative Crockett's argument before the Supreme Court and the subsequent ruling in Henderson County offers several key insights into the workings of the court and the nature of effective constitutional advocacy. First, it underscores the power of meticulous preparation and deep subject matter expertise. Crockett prevailed not through political rhetoric or emotional appeals, but through her comprehensive command of the facts, the relevant case law, including her opponent's own writings, and the procedural history. Her ability to anticipate and directly address the challenging questions from multiple justices, grounded in specific evidence and legal reasoning, was the cornerstone of her success. It highlights that, even in a highly politicized environment, substance can still triumph over status or political affiliation, especially within the unique, intellectually demanding arena of the Supreme Court. Second, the story showcases the strategic importance of connecting constitutional principles to human consequences. Crockett effectively bridged the gap between abstract legal doctrines, like disparate impact and discriminatory intent, and the lived realities of voters facing barriers. By grounding her arguments in specific examples and demonstrating the tangible harm caused by the state law, she made the constitutional stakes clear and compelling. Chief Justice Roberts's unprecedented acknowledgement suggests the power of advocacy that appeals not just to legal precedent, but also to the fundamental purpose of the law, to protect the rights and dignity of individuals. Finally, the narrative serves as a reminder of the court's role as an institution capable of transcending partisan expectations. While deeply divided on many issues, the 6-3 majority in Henderson County, led by the Chief Justice, demonstrated that the court can still find common ground based on evidence and established legal frameworks like Arlington Heights. Roberts's opinion, and his specific citation of Crockett's oral argument suggests a judicial process that, at its best, remains open to persuasion based on the strength of the evidence and the clarity of the legal reasoning presented. It offers a counter-narrative to the perception of the court as merely a collection of predictable political votes, suggesting that principled advocacy can still shape constitutional outcomes.